What happens if a parent violates a custody order? My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm is a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. What happens if someone violates a custody order? So let me paint that picture for you. We have a court order. Let's say it's a result of a divorce. Custody order says that dad's going to have the child on these days, mom's going to have the child on these days, and what happens? Comes dad's days, mom doesn't cooperate. There's a problem. The child's supposed to be available, dad comes to pick up, where there's a note on the door, sorry, left town. Don't think it's unrealistic. It happens all the time. What is someone supposed to do if the other side is simply non-compliant with the custody order? Well, you have to understand one thing. Number one, a custody order is very much a court order just like anything else. And just because it doesn't come out of business court or criminal court, but it comes out of family court, doesn't make it any less powerful and impactful an order. Which means if somebody violates the order, they are in contempt of that order. And they can be held in that contempt by the filing of a motion. Here is the process that, let's say it's a dad, that a dad would have to follow in order to have the mom held in contempt for not letting me have his parenting time. He'd have to have his attorney file a petition in order to show cause why the mom should not be held in contempt for violating the court's order. That's what the petition is called. And you would seek a hearing as soon as possible at the court's first available date, and the court would conduct a hearing, and the court would hear proofs. And the proofs would basically say, they'd go like this. The lawyer would say, look, you gave an order on such and such day that we're supposed to have parenting time under such and such schedule. My client came to get the parenting time. She's out of town. No excuse, no nothing, no accommodation, no change in the arrangement, just gone. All designed so that my client doesn't get his parenting time. So this violates the court order, and we're asking that they be held in contempt. Then the court will turn to the attorney for the other side, or the other person if they're not represented by counsel, and say, okay, you've heard the allegation. Well, what's your excuse? How do you plead? Did you do that or not? What's going on? What's the excuse? Is there a justification? Did you try to make an effort? Was there an emergency? What's going on? If the court is satisfied that there was an emergency, the court will probably warn the parties that they have to, communicate in advance, but probably will hold off on holding someone in contempt if the court is satisfied it's a bona fide emergency. However, if the court thinks that it's bona fide BS and the court does not believe that there's an emergency and the court thinks that the other person is simply playing games, trying to manipulate the situation, the court will likely tell them one of two things. Either they're going to be, or they are, held in contempt. And when you hold somebody in contempt of an order, the judge has all sorts of remedies. The court can fine the person. The court can order that they not only are fined, but they have to pay the attorney fees from the other side having to bring this motion. The court can order make-up parenting time. The court can hold the person in contempt and put the person in jail or any sanction up to that the court deems appropriate. So the court has wide latitude in dealing with failures to comply with the custody order. So it becomes very, very important to do that. So I would say this, oftentimes you're dealing with not a short game, but a long game. In other words, you got a child who's 5 years old. You're going to be dealing with this issue for 13 more years at least. If the mom does this once in a while, you might think, not so bad. But I'll tell you something. If you get the impression that this is going to be a repeated problem, the better strategy is to bring it to the court's attention every time it happens. You file a petition for contempt, and you get the court to say, yes, this does violate my order, but I'm not holding in contempt. I'm warning you, you better not do it again. You do that, you may get a judge. That judge may issue 2 or 3 warnings. But I want to tell you, if the judge issues 2 or 3 warnings, by the 4th time they do it, at that point, the court is ticked. And you know what? Your attorney stands up and says, Judge, on such and such day, you gave him a warning. Then you gave him another one, a third one. It's enough with the warnings already. We're asking that the court change custody. And you know what? The court may very well do it, because the court may say, look, obviously they can't work together. This person doesn't care about my orders. I'm not rewarding them with an ongoing custody order. So the court could do that. These are all sorts of things that can happen. And my advice to you is, if you're in that situation where you feel like you're being abused within the realm of the court orders, you need to take these steps that we've outlined in order to vastly improve the situation as it is. If you have any questions about that, reach out and we'll be glad to help you out.